So I just wanted to say hi and welcome. We appreciate everyone attending. If everyone could take 1 second and put their name and what they do, so what type of construction or any other business that they have, so we can tailor it a little bit to address that. Um, I'm Jennifer Elmore, and I'm going to hand it off to Robert to introduce himself, and then we'll move on as helpful
Good
as
af
possible.
Good afternoon, Robert Lowry, Field Support Project Executive. One of my main roles is providing technical support to the contractors in the field, bid document reviews, change orders, construction and completion. So I'm more of a hands-on in the field. So that's where my forte is. Also doing quite a few of these trainings and workshops.
Next slide, please. And I do want to apologize in advance. I'm slightly allergic to, majorly allergic to acacia trees, and there are four of them in front of my house. So if I do have a coughing fit, Robert will take over. So, and then I also wanted to extend, as Connor said, if you have or you have a particular question, at any time, raise your hand and I'll give you through Connor the floor. So let's start off with the really disclaimer stuff. This information provided in this webinar does not and is not intended to constitute legal advice. Instead, all information, content, materials available are for general information purposes only and given as a result of Merriweather and Williams, a hub company's experience working with small and emerging contractors. The webinar is not to be construed as a substitute for review by legal counsel or other professional advisors. It is our recommendation that contractors should have an attorney review all their contracts. The purpose of this webinar is to give you some insight into your contracts and how contracts affect your relationship either with an owner and or prime contractor. Next slide, please.
So,
So, as I said, today it's to review pitfalls that we have seen in our course of 30 years. It's embarrassing to admit, but 30 years, because I started when I was three, 30 years working with contractors, and Robert started when he was two. Um, Things that we've seen when working with business development and helping the contractors. And we want to see that, you can identify your risks and see how you can avoid them. And then one of the things that we're not discussing here, but is in the title of the seminar, is where you can potentially and where you can't negotiate in terms of contracts. And that's really important. Next slide, please. Okay, so essentially we break the seminar down into a checklist, and we do have a checklist when the summary of the seminar, the checklist will be attached, and it'll help you to kind of go through your contract that you're looking at. And what we always recommend is using Adobe. You can do an Adobe search. So if you look at your contract, there are three sections of it in the way you look at it. One, you read for accuracy. Is everything correct? And then the other is sections that you need to review, whether the language is in there or not, and how that language will impact you. And then the other are sections to pay close attention to and which require potentially more research. And so what's really important about that is we want to make sure that everyone is aware of is you can negotiate with a prime or a subcontractor. And once you get to a certain point and it is in writing and you go to sign it, all of those previous conversations are no longer part of the contract. They become what we call null and void. They're not a consideration. So it is what is within the contract documents that you have. So we're going to go through these. Obviously, I'm not going to read these to you because you can read them yourselves. So we're going to go to the next thing. And once again, review your contract before signing. And when you're looking for accuracy, go to the definitions page. It will tell you definitions in the contract. Some of the things to pay attention to are, who are the owners of the contract? How many people are named and listed? Other things that you need to look at is is it calendar days or business days that you need to look at? Because that will impact you when we get to the change order section. If you submitted an estimate with inclusions and exclusions, have those been listed in the contract? Usually or oftentimes what happens is they take your estimate or project scope and attach it to the contract. Make sure it's attached correctly. Does it give you a good example of project overview, or have they expanded the project overview to include other information that you did not include? Is the contract amount correct? There are mistakes that can happen. Milestones and deliverables, the schedule and timeline, and then management. So read all of those sections for accuracy. I recently was working with a smaller contractor, and they received a contract to review, and it was for a City of Oakland project, but the project referred to Sunnydale the whole way through, and there was nothing, they needed to make that change, and it was good that they caught it in time. Next slide, please. Okay, so one of the things is that you really want to make sure that when you're looking at it, you want to read beyond the standard contract documents, and what is included in your 5 to 10 to 20 page documents are the drawings, the specifications. If you're a subcontractor, the general conditions between the owner and the prime, the bid package documents. All of those things need to be read for accuracy. And in case you're not aware of, you can ask for a copy, and it may be redacted from the contract between the prime and the owner. If you're a subcontractor, they may redact it for proprietary, but they have to give you the information that impacts you and your contract. Next slide,
Hey,
please.
real quick, I just want to chime in.
Yeah.
Sorry, Jen. With
No, no.
these contract documents, remember the schedule is part of the contract as well. So make sure that you review and make sure that your part of the schedule is accurate, because once that is put into the overall schedule, that becomes a document that is part of the legal document, that schedule. So make sure that it's right. You know, they'll give you the opportunities to go through and put your timelines in there. Make sure you identify your long lead items, submittals, all that should be in your schedule before you admit to this contract. Because once you're in there, you're locked in, you're locked in.
So one last thing to add to what Robert said is and I may or may not have gone over that in this presentation, but when your contract, and every contract says it, is time is of the essence, that means that the schedule is elevated to a breachable offense if you cannot follow it. So Robert is absolutely, thank you for adding that. And Connor, remind me to add schedule to this to make sure we elevate that to the importance that it has. Next
And one
slide.
other one
Yes.
is special provisions that's in the contract. Most of the time, these contracts will have a section on special provisions. Review that, because those are some areas you can negotiate some of the special provisions. The terms and conditions are some also places you can negotiate, but a lot of the boilerplate stuff is not going to be negotiable. So that's one thing you want to be aware of as you're going through your contract here.
Okay, so once again, we're still sticking in the section for accuracy, and I want to take this moment just to say, does anyone have any questions before we move on? I don't want to run too quickly through something. Okay, so just know that,
Once again, I'm sorry.
no,
Yeah, it's
no.
just everything's just sparking here. Because after 30 plus years of doing this, another thing that you want to be aware of is your preliminary notice. Make sure that you know the owners and everything else, because when you sign this contract, you want to be able to submit that prelim notice. And we'll talk more about that later as well, because that's a big legal thing to protect you in case you need to do claims or stop work or whatever. If you don't file it, you have no legal right.
So you're jumping ahead to the stop notice
Sorry.
mechanics lien
Sorry.
section. Oh boy. No, I'd rather have the information out there. It's actually, but
Yeah,
you're right. This is, that's about accuracy and reading through your contract.
correct.
So one of the things is every contract has some type of dispute resolution. And it's important to know, um, and there's different types. There is mediation, there's arbitration, there's litigation. But what your contract will lay out is what is the procedures for this contract. Oh, go ahead, Amir. We can't hear you.
Is your speaker working, Amir?
Or you can type it in the chat, and then Connor can read it.
Yeah.
Yeah. If you want to type it in the chat, I'll read it out. It looks like your mic may not be working. Oh,
Oh, notice to proceed.
Okay. Notice to proceed. So I will go ahead. So, depending on what it says in the dispute resolution, usually mediation is more that you're working with a third party. It may or may not be a binding resolution, whereas arbitration is often that it is a binding resolution. The litigation. So one of the things when you're looking at it is you need to look at who pays the cost of the dispute. Because you also need to know what state governs the dispute. So let's say for example, I'm going to pick on Hensel Phelps. You have a contract with Long Beach, and you're having a dispute with a contractor working on the Port of Long Beach, and Hensel Phelps is the prime. In Hensel Phelps dispute resolution, they ask you to go to Colorado in order to do it. And so that is a point where if I were in a contractor's or a subcontractor's shoes, I would then ask for the dispute resolution venue or place where it happens to be moved to California, because that's where the alleged incident happened, as well as it should be governed by state of California law, because what happened that led to this dispute was in California. So the reason you want to, that is a point where you can negotiate. You also want to know how this impacts you, because if you have to fly yourself and your staff to Colorado, there's a significant cost to that. So just be aware of all those. So, and then obviously if the project is in California, state of California law would be preferable to other law. Next slide, please. Was Amir able to ask his question?
Yeah, he was talking about notice to proceed.
Oh, we'll get there.
Yeah.
So there are two clauses, contingent payment clauses, that are usually found, and the shorthand of them is one is pay when paid, and the other is pay if paid. Pay when paid is still found, not as often, but a pay when paid means that your prime or your owner has to be paid before you can be paid. Pay if paid means that you need to be paid even if they don't get paid with a reasonable amount of time, and whatever that reasonable is up for you, is up for dispute, but you need to get paid for work done. Now, in California, pay when paid is illegal. So if you see that, I would recommend bringing that to their attention. Now, the following states, because I don't know where everybody is pay as of 2023, pay if paid clause, pay if pay, California, Delaware, Illinois, Indiana, Kansas, Montana, Nevada, New York, North Carolina, Ohio, South Carolina, Utah, and Wisconsin are not allowed. So you want to know what they're doing. You want to make sure that even if they don't get paid within a reasonable amount of time, you get paid, and that protects you should there be a bankruptcy at the developer's level, and this is especially on private or P3 type projects.
Jeff,
Robert, do you have something to add?
I was gonna say Amir did ask us. He said, "What docs will need to ask from a prime if they refuse what we can take action?"
Oh, so at that point in time, so usually in the 25 to 30 years that I've been working, we've never had someone refuse documentation to release it. It looks a little bit like a CIA blacked out for certain sections, but they haven't refused it. But one thing you can do is you can go around them, and you usually on Public Works, you can go into the Public Works and download their specifications. The contract template is public knowledge, and you can pull it out of there. It won't have the specifics, but it'll give you the terms and general terms and conditions as well as the contract for you to review and how that may impact you. It's
Uh,
always a good idea to do anyway. Go ahead,
did
Connor.
you list California on the paid when list?
Yes.
Okay.
Yes. California is one of the better states. And obviously, I'm biased since I'm in California for contractor protections and subcontractor protections. Um, and as a Californian, I'm biased. So um, we'll move on. Any other questions?
One thing I just want to say about this payment clause. Larger GCs will try to manipulate smaller ones here. Know your rights and stand up for it is the biggest thing here because they're going to assume, well, this is a small trade partner. They are not going to know the legal stuff. But this one thing that Jennifer is talking about is very important to protect you successfully so your business doesn't go out of business because you depend on this money. And there's
Hmm.
also options where you can ask for early pay that you can negotiate that too. It might be a percentage, but it's things that you should negotiate before you sign. So this payment clause, once you sign, you're locked in.
So some of the things too that you can use to help you to bolster your argument is that, for example, depending on where your project is, the state of California has, when they pay a prime contractor, the prime contractor has 10 days to turn around and pay you. So that is one protection that if it's not in the contract, you can bring to their attention. I know in the city of Oakland, the city and county of San Francisco, that's brought down to 3 days. Robert, do you know what it is for Los Angeles?
It's 7.
Seven
Now,
days?
the trick part for this too is when the clock starts to tick, is after the Prime's pay app has been approved. So there could be some back and forth that's going on, and it could be 60 days before you get paid, and your contract is saying 45, 30 days. So you need to understand how long is it really going to take for you to get paid. And that's one thing. It's like, I submitted my invoice, and it's been 30 days. Well, you got to realize that there's multiple subs on this, right? And then collecting everybody's pay apps to submit the whole packet to the owner. There could be times where, with another trade partner, billing gets kicked back and they're holding up to submit the whole packet. Hopefully, these GCs are not doing that. But those are the questions you want to ask when you are reviewing and having this meeting with the hiring agency. It's like, how do you handle the pay apps? Do you hold up everybody because of one? Also know the due date of when you need to submit. They might ask for a pencil draft to review it to make sure it's right. So that is time that you need to put into your schedule to make sure when you get paid. And that is your forecast of when you got to pay things, when you're going to get paid. So that is very important to understand the financial part.
So just to go back to the pay when paid, that is enforceable or allowable in California.
Hmm.
You can have it in your contract. It just means that if they don't get paid, you have to wait a reasonable amount of time
Mhm.
for them to do what they need to do to get paid. But ultimately, if you've provided work, for lack of a better term, they're on the hook for paying you.
Mhm.
And so that is what rules in California. This is based on a question that was in the chat.
Okay.
Um,
I was gonna,
okay.
that's one you were answering, right?
Yeah, yeah.
Okay.
And we are going to go over prompt payment. But one of the things that is really great about nowadays is, to find out some of these questions is please feel free to, when something like this comes up, all you have to do is, let's say you're working for the County of San Bernardino, you put it into Google prompt payment County of San Bernardino, and it will come up what their rules are. And as Robert said, it's a matter of timing. That prompt payment or the timing starts when they have been paid. There may be that 45 days delay, but that's a really good, so you know what's going on. Um,
Yeah.
Next slide. No, sorry, Robert.
No, it's just me chit chat. The other thing you need to be aware of is if you're on a multi-year project and your work is early and there's retention is out there, what is the clause that's listed for you to get your retention? You don't want to wait 2, 3 years to get your money. So that's another thing you want to look at in that payment clause as well. Because that has been over the years, I've seen a big stickler for small contractors. It's like, hey, I need to close this job out. I need money, but it's still sitting there. So negotiate, it's like, okay, owner, will you sign this off so that way I can get my retention and get out of there? So things like that you want to be aware of. I'm good.
Next slide.
Please. So the next is termination for convenience and termination for default. You will find these in almost every single. We're focusing right now on termination for convenience, and that's when a prime or an owner says, we don't want to work with you anymore. We'll pay you up until what you've done, but we're gonna let you go. Um, and one of the things I like to say to our contractors is try to negotiate if you can get it to be a two-way street. Oftentimes, termination for convenience is weighted to the prime contractor or the owner. See, make sure that you have an escape hatch as well. Um, and then what you need to do is also look at if there's a termination agreement, look at how they will pay you, how much, what are the agreed upon payments in there, how that is. Oftentimes, they may terminate you for convenience and not pay you all the work that you've done. So make sure you're aware of what those are. Um, Robert?
One thing that you also need to be aware of, they need to give you in writing some warnings. This cannot just happen out of the blue.
So that's termination for default usually language.
Yeah.
So the termination for convenience, I also have to say, is essentially at most municipal levels or public works or government contract, absolutely void because usually the contract between the public entity or the government takes precedence over the prime contractor's contract. And usually, if you are a small and emerging contractor and certified, they are not allowed to remove you without going through a certain process that has
Mhm.
been defined by the owner. But
Correct.
I always, they're not usually, oftentimes they won't remove things. But I would like for the subcontractors or the smaller contractors just to have an escape valve if they want to get out of the contract.
There is a question in the chat as well.
Yes.
The lead time for the retention also negotiable in a payment clauses?
Yes.
Yeah.
Yes, absolutely. So one of the things is you still see some contracts with 10% retention. One of the things you can do is right now with the state of California, the majority of public works contracts only have a 5% retention clause. As Robert said, you can also negotiate at the point where you could say at 85% of the contract, if the work is accepted, that you will release 50% of the retention and have a slight scale so that you're not stuck with it, as well as what's really important. If you go in and you are the concrete and you're laying the foundation, that you negotiate when your work has been accepted and totally completed, that you receive all or the majority of your retention because you don't have 2 years to wait until that building is built. So those are things you can negotiate. Okay, so then let's go to, unless anybody has some questions.
There was beneath that, he said, and timeline. Also, do we need to have a cert of completion?
Robert?
Yes, you need to get that notice of completion or substantial completion, whatever the language is, you need to have that. And also, if there's punch list items, you've got to complete your punch list items before they will accept releasing that retention, because that's why they have that there, because they're holding that little bit of money back until they are happy with your work. So the best thing to do is try to have a zero punch list at the end of your scope. Have them to inspect. You do your own quality control to make sure it's great, because you're going to lose money if you got to come back to do punch list items. So you got to realize punch list items can hold up that retention as well, and your closeout documents that you need to provide. So understand what do they want for your closeout, and that will help with that retention there.
Okay, so the next is the termination for default. This is where the prime or the owner is viewing a subcontractor contractor as having a complete or partial anticipation of failure of the work. Now, what's really important to understand, and this is what is in your or should be in your contract, is what are the triggers for those termination? And then once you have those listed, what is the timeline to fix it? So is it 7? So oftentimes you'll see 7 days written notification, and then you have 3 days to what they call cure. Now, are those calendar days or business days? So what you can do to fix it. And what we always do is document everything you're doing along the way. Robert, I know you got something here and I want to hear it.
Now, this is important with your daily logs. Is if you should be doing your daily logs and document anything that happens. The more information that you have in your daily reports and your daily logs can help you defend if they're trying to terminate you for this default. So having your field foreman, whoever it is, write it out. If there's visitors, anything that happened that you were close by, whatever, document it. Because what's going to happen, they're going to point the finger at you even though you weren't involved sometimes. So be careful and just document, detailed documentation.
So also one of the things on public works projects, there are contract compliance officers or civil rights office. Immediately contact them for support and help, to make sure that you can show your documentation and they may be able to act as a mediator in this instance. And there was a question.
Yeah, do those docs need the owner confirmation?
Which can somebody which docs?
This is same as it's on Amir's chain. Also, do we need to have a cert of completion? Thanks. Do those docs need owner confirmation? Amir, do you mind mentioning which docs you're referring to? The docs Robert explained.
Oh, okay. Yeah,
Trying to
the daily
confuse people.
reports. Yeah, the daily reports and everything. What I used to do is have the superintendent, sign off on your daily reports too. So they agree. That's like, yes, the owners really don't get involved. but unless you go to mediation and everything else, then these reports, they might ask for it. So that's the thing of having them complete, and whoever hired you, that superintendent put their initials on it, and then you save it. Yeah. Hopefully that answers Amir's question. Yeah.
He said thanks.
All right. Next slide. So this is kind of so no damage for delays. This is what I call a risk shifting mechanism or clause in a contract. And so what it is trying to do is say that if there's been a delay on the contract that was not caused by you, but caused by someone else, that you may not make a claim for it. And even if the owner or contractor, and this, there could be increased costs due to a delay that you have not caused. You need to have more workers, and this is one of those that could impact your contract, impact your pricing. And if you've already signed this is where we recommend trying to get this stricken out of your contract or modified, especially if the delay is caused by an upper tier party. Robert, do you want to add something?
No, you're spot on. And with these delays, you should understand what are your daily general conditions are. Because if it is delayed and your contract is, say, 60 days and it's pushing it out another 10 days, you need to be able to recoup that. And if you need to demob and remob, those are costs and those are impacts that you need to be aware of when these delays happen. So I'll stop right there because I can go on and on with that. Yeah.
So one of the things is that this clause may be void in California, and so it may not be enforceable, and in North Carolina as well. It is permissible in the state of Texas, but it's one of those things that where even if it's void or permissible or not permissible, if damages, if delays cause damages to your bottom line, they need to be acknowledged. So one of the things is you can always go to your area where you work and Google no damage for delays clause and to see and ask if it's enforceable. It's one of the ways to protect yourself. And if you see it, and it may conflict with the general conditions of what the owner says. So we'll leave it at that. Next slide, please.
And then if delays happen by owner crews like owner RE REPA, what is the solution? Rep.
So
Rep. If delays happen by owner crews or owner rep, what is the solution?
So this is where I'm going to say what Robert's going to say, even if you need to document it. You need to show with numbers how this impacted your schedule in terms of crews, in terms of the extra costs, because it is no fault of yours. And if you can document that, submit it with a change order according to the change order permissible
Language.
schedule, and I would submit it as a change order.
Yep. And that's where you would, with the schedule that Jen was talking about, your time impact analysis is it's a schedule. It's a real short one, but you want to be able to show how these delays are impacting you. So that's what it's called, a time impact analysis in your schedule, because that's going to help you get that change order that Jen was talking about.
And then, sorry, one second. Catalina, did you say next slide? We aren't seeing any slides. Is everybody not seeing slides?
I can see the liquidated damaging slide.
Other people in the chat can let me know if they're not seeing the slides. They should
I see liquidated damages.
Okay.
Thank you.
Okay. Thank you.
If everybody's going to get a copy of this and a summary afterwards, So if we do have a glitch, the glitch will be, the matrix will be restored within a week or so, right, Connor?
Yeah, yes.
Okay. All right, so liquidated damages or LDs. These are really, really important. They are to compensate an owner or a prime. And this is once again about that accuracy reading. You need to review these. The accuracy reading is that schedule, the milestones, and are you meeting those? Because the liquidated damages are triggered by not meeting the schedule. And the delays that are coming is they are attributed to you, your crews, and that goes back to one of the reasons why if there's delays from the owner's rep or higher up in the schedule, that you document it so that the liquidated damages don't come to you. Now, in general, liquidated damages are not meant to be punitive. They have to be ascertained and figured out in advance. They're supposed to be fair, what the delay would cost, and they're not usually a definable loss. So it's not as if you can't open the store in time, this is how much revenue you would lose per day. They're a little bit nebulous and it's kind of a set upon. And one of the things about the liquidated damages is you want to also look to what the prime contract or the master contract is and make sure that their liquidated damages are the same as in your contract because they may flow down to you. And we'll go through that later. But it's one of the things, and this is where you should review it, one, to negotiate if you can get them lower. Two, to make sure that liquidated damages do not include manufacturer's warranty. So because that's one of the things that we've seen a mistake where they made a mistake and added liquidated damages for a manufacturer's warranty delivery, and it was just too high, and therefore we were able to negotiate that lower. And I'm sorry I sound like the boogeyman a little bit on everything that can go wrong.
With these also with the liquidated damages, and it goes back to the schedule. If your work is on the critical path, everybody knows what the critical path is in the schedule, which drives the end date. And if you're on that critical path, it's going to be very tricky to negotiate liquidated damages. Now, if you're not on there, then there could be some wiggle room to lower it because sometimes it could be $5,000 a day or whatever it is. It's ridiculous. So be aware of that even before you even bid the job. What is the LDs? And then you look at that schedule. Am I on that critical path?
Any questions?
None in the chat.
Okay, then let's go to the next one because we've kind of talked about this. All right, this is one that I want you to definitely, when you're reviewing your contract, look for and make sure it is not in there. And this goes back to a no lien clause. And the purpose is that they're asking you to waive your right to do a lien, a mechanics lien, or a stop notice. And each state is going to be a little different. In California, North Carolina, and Texas, it is prohibited to waive your lien rights, and usually not enforceable, but it's one of those things you need to get rid of. And that goes into Robert's preliminary notice. That is one way to preserve your rights and to make sure that you are always maintaining them and so that you get paid. And just in case, on a side note, mechanics liens are on private property because you can put a lien on the property. Stop notices are on public works. And usually when you're doing public entities, state of California, then what you do is you can Google how to do stop notices if in the city of Los Angeles. And usually there'll be a website and a form on the website. If not, you can choose a generic form in order to get the language for the preliminary notice and then the stop notice. So any questions? Robert, any comments? No. Well, don't make it too easy on me.
Yeah. Question.
Yeah, yes.
Yeah. Hi. So it says here, Public Works, uh, stop notices, are for Public Works. Does that mean,
Mhm.
what about if you're on a government job? Would that also apply there, a stop notice, or
Yes.
just a
So,
mechanic's
so
lien?
think about this. The government doesn't technically own any property, and that's why you can't do a lien. Anything that is public or government is usually regulated by stop notices.
Okay.
Now,
So,
oh, go ahead, sorry.
that's only, if the government owns the property. If it's, for example, if it's leased, then it's not, it would be go private then?
Okay, so this has come up recently, and I'll give you the scenario, and you'll let me know if it fits you. So we had a contractor who was doing a remodel on a leased property at the San Francisco International Airport. And the question is, because it's San Francisco property and a leaseholder, what were the rights? And it came down to, even though this was a private entity, because it was on Public Works project, it had to go through the stop notice process. Does that help?
Yes, thank you.
Okay. And then yeah, Robert, any add? Because the procedures are so, one of the things, for procedures for um, preliminary notice and stop notices are very regimented. Just make sure you get that preliminary notice in to protect your rights. Oh,
And
and then go ahead.
you should do most time that prelim notice is 20 days from the time you sign or you get your NTP. 20 days, you want to get it in. Early, the better.
Mhm.
Some of the large GCs might bark at you when you send it to the owner. It's your right to send it,
And
to let them know
studies
that
are,
you're going to be on the project.
so
Yeah.
studies have been shown that people who file preliminary notices have a tendency to get paid more quickly. And I don't know if it's their organizational skills or that they've put in the notice. And then the other thing is, just remember, if you are on a public works contract, there are things like civil rights office, contract compliance officers that you can also notify when you have not been paid. And they are there for that as well. And they're a great resource. Oh, notice to proceed is NTP. Okay. Next. Oh, no.
All right.
All right.
Oh, we're on. You did this.
Next one.
Yeah.
Yeah, subordination of lien. Um, this is similar to the previous slide, and it's subordinating or not quite waiving, but making sure that it's a lower importance of mechanics lien clause, and it makes the priority of the mechanics lien less, and it has to do with who gets paid if there are issues on the project. If and so this is one of those clauses that we recommend that you try to get rid of, or at least be aware of if it's in the project. So, because if there is a bankruptcy or something wrong on the payment of the project, if you subordinate your lien, that means the priority of paying everybody, you're the last person to get paid. And we want to make sure you guys are the first people to get paid instead of the last. Robert?
Um, with some of these liens, they should be listed in the terms and conditions or special provisions sometimes, well, more in terms and conditions. Make sure when you bid the job, you understand these liens too. So ask for a copy of the contract, when you're bidding these jobs, so you know what you're going into. So when it's time to negotiate and review, you've had time to look at that owner's contract.
Mm-hmm. Okay, I'm going to say next slide, please, unless anybody has any questions. Okay. Now these are sections that in the contract. So now we've gone, it wasn't accurate. This is what you need to review, and this is what you need to pay attention to. And these are, flow down language. And you can see that in your contract that it's either the terms are incorporated by reference or flow down provisions. And essentially what it is that if you are a subcontractor, all of the language from the general conditions from the master contract between the owner and the prime now flow down into your project. And so this impacts the general conditions, dispute resolution, and liquidated damages, to name a few. Now, some of the things that you might want to look at as well is they will list what documents, often in the preamble or the beginning of the contract, which documents are incorporated by reference. So you know exactly which ones you have the right to ask for from the prime or the owner. And so this could impact your contract substantially and what's allowed. Now, one of the things you want to see, and it may or may not be in the language of the contract, is if there are two languages that don't agree, which one takes precedence? And it's often the general conditions of the owner that take precedence, but it's something that you want to look at and find out if it's not in the contract. Which one prevails? Which one wins when they are not in agreement? Robert?
Yeah, that's very important. And if it just says in your subcontract agreement, flow down, and there's no documents, you should ask for it during this time because you don't know what is being flown, coming down to you. So I've seen contracts where they said flow down, and it's like from the owner. You're like, well, what is it? They
Lava.
must tell you exactly what it is. It could be insurance requirements, the bond, public works, or it could be like the prime could cover your bond and it's not required down to you. So those are the things you need to understand because that's a cost associated too, and you need to know what it is. That's it. I know I am tracking time here.
I know. I'm trying to be cognizant that everybody has valuable time. Okay,
Yeah.
next slide, please. Okay, I think this is one of the ones that obviously I think everything's important, but I think change order language is the one that might or might not impact everybody the most. And so one of the things we're looking at here is you need to pay specific attention. And when you're looking at it, what are the timing requirements? And I'm going to go back to, is it business days that you have to get it into them? Is it calendar days? So if it's 3 calendar days and you need to submit a change order on Friday, by Monday, you've almost missed your timing. So that's one of the things you want to make sure you know. You want to look at what can be included in the pricing. And oftentimes they will list what's the insurance, what can you do, what is a direct or indirect cost that you can include in your change order. You want to make sure you don't leave anything on the table. Robert mentioned bonds. Let's say that your bonding is 2%. You want to make sure that increase to your contract is included because bonds increase and your premium increases as you go along on the project. What are the allowable markups? What happens if you do not submit timely? And then one of the things that is really important is there notificant language of a material change that is required to the surety company if you have a bond? One of the things I also, because this is so important, I want to, before I hand it over to Robert, mention there is a change order seminar on our YouTube channel that is well worth visiting. You can spend some extra time there with Robert on the YouTube channel and going into this in more detail. With that, I'm going to hand it over to you, Robert.
I'll keep this real brief to maybe a minute. With change orders language, you need to understand how many days is it that you need to submit. That should be in there. Um, what happens, if you submit the change order and they are dragging their feet, make sure that you get that acknowledgement, yes, proceed with the change order. Because most of the time is of the essence. And it could say they have 7 days to return this change order to you. You might not have 7 days. So getting in writing, they say, yes, proceed with the change order is very important. The other thing is not only bond, but your insurance, whatever that percentage is for your insurance, because your contract value is going up. Include your general conditions to as part of this and your profit. Now, if you're a GC and you have subs underneath you, your markup cannot be the full amount. It could be only 5%, and your subs is doing the work is 10% because you're only managing it. So understand the other thing is ask for a sample of their change order form. What do they want? Majority of the times for you, this is like when you're in court, you're trying to win a case, you want your money. You want that RFI, request for information, that you submitted that's telling you, oh, do this change order, right? That is very critical because that's going to tell you what to do. The next thing is, you want to have any supporting documents to come up to that cost. Let's show it because it's a packet. You want to tell a story of it. If there's extra days, put that in there. So I could go on and on and on with change orders. The other thing, you want to make sure that you get this change order approved in a timely fashion. Because what happens if you are, short time on the job and you have left the job and you still got open change orders? You have lost your leverage on these change orders to negotiate. And plus, you want them approved so you can do your billing. So there's a lot that goes into this change order language. Really understand what is in that contract with that. That's
And just to make it scarier, pay attention. There might be different language and different timing depending on whether it's a field generated change order or an owner generated change order and how long you have to respond. So just keep that in mind.
Then we have do we need to include bond expenses in change order, or could we claim?
Yes, yes. You won't have to pay them till the end, but that's definitely something you should try to ask for. Let's say, the change order is for a substantial amount to your contract, and the bonding company is going to ask for that at the end. And so you want to make sure you're covered. In the same way, your workers' comp costs will increase because you've done more work than you thought you were going to do. So you want to make sure the insurances are in there as well.
Yeah. And you make sure that if the superintendent of the field is telling you to do this work, he is not authorized to tell you to proceed with it. It is PM or whoever it is. So if he's in the field, say, hey, do this, do that, I said, okay, let me go back to the PM, whoever it is to sign your contract, get that from them, because that's what happens if you don't submit it in a timely fashion, or you never submit and they tell you to do the work in the field. You got to protect yourself.
So for expediency, I'm going to say next slide. We'll bring up warrant. So warranty. Okay, so what is the warranty period? What is the relationship between warranty period and performance payment bonds? And then double check warranty period versus manufacturer's warranty. The warranty period is usually built in a year, and that's built in when you get a performance and payment bond. There's automatically a 1-year warranty period built in for you to fix defects, minor defects. If it goes beyond that, the surety is going to charge a surcharge to it. Just be aware of that. And so one of the mistakes that I have seen that have happened is that manufacturer's warranty was accidentally written that it had to be provided by the contractor and not by the manufacturer, and this was a painting. It was a 10-year warranty period, which should have gone towards the paint manufacturer and not the contractor. So make sure all of those warranty periods are correct and 1 year or less. And if they are more than a year, let your owner prime know that there's going to be an extra cost for the bonding beyond your standard premium so that when you're handing it in, that's calculated with it. And so we just wanted to make sure you were aware of it and that there are no hidden warranties coming from the general conditions that you as the subcontractor may not have been aware of. Robert.
Yeah, one thing with these warranties on multi-year projects, and you're first, and the project is 5 years later. When does your warranty start? And like Jen said, there's also the manufacturer warranty. Manufacturer is going to start once you have put that equipment in the field and it's activated, it's started. So you need to get special language in your warranties. And they can also have you say, my work is finished. The architect of record can come in and say, yes, your warranty can start. Now, if you have to come back and do trade related damage because somebody messed up your work, then that's a change order. That's warranty. So there's a lot of things when it's not cut and dry with warranties on short project. Long ones, talk about these warranties when they start.
And whoever asked a question, the standard warranty without being convoluted starts at substantial completion for the year. Yes. Okay,
And
we're
then
gonna go
you
on.
can also, now if it's a manufacturer warranty, the manufacturer is covering their equipment, not your labor to make the changes. So you got to look at that language with your manufacturer warranty. So you could come back and say, okay, the manufacturer is covering the equipment, but not my labor. Then that could be a change order too to come back, during that time of the warranty period.
Mhm. Next slide, please. Okay, this one's near and dear to my heart. This is progress payment language. What is the timing for payments? This is, once again, this brings up retention. How much they're going to take. What I always say, negotiate for 5% if you can, and negotiate in advance the release dates. What documents do you need to do to accompany the payment application? And does the contract say anything regarding slow payment or non-payment? That kind of goes back to the pay when pay clause, but it's also if things are delayed, if it's a 120-day cycle, can you negotiate an advance payment? Can you, because you guys are responsible for paying people on a weekly basis. What can they do to help you bridge that gap? And so that's really important to negotiate where you can in advance, as well as progress payments. One of the things, and we'll probably bring this up later, is make sure there's nothing in there that costs you anything. Oftentimes, a lot of the primes will have a system called Textura, where it'll cost you a certain amount to submit your progress payments and to get paid out of the system. It may expedite it, but there's a cost factor for you in it. So those are all the things you're kind of looking at in this. Robert?
Yeah, that texture, that should be listed in your invitation to bid, what kind of billing system they are. Then you can put that price into your general conditions. The other thing is with progressive payments, they're going to most time require conditional and unconditional liens. And those liens are saying that, yes, I've been paid. Now, this also goes down to your suppliers. You're going to also need to get those liens from them as well to put with your payment app, because they're going to say, well, how can I verify that you have paid your suppliers? So you're going to make sure that you have these conditional means you haven't been paid. Unconditional, yes, you've been paid. So there's making sure that you have all that. And I like to use G702, 703 with your pay app, as a pay app, and these supporting documents there too.
And those are AIA forms that you can get for free on the web. Just if the people try to sell them to you, you should be able to get them. Thank you. You may have to, um, the owner or the prime should give you all the forms that they want and the format that they want everything in. And then this is where also um, pay attention to the mechanics lien, the preliminary notice and stop notice process on this particular project to make sure the progress payment is expedited. Next slide, please. We're trying to be cognizant of your time. Oh, the difference between conditional and unconditional waivers. The conditional waiver is what you submit when you're submitting your payment request. When you receive the check from whomever is paying you, that's when you submit the unconditional and it'll say conditional on progress payment. And when you're at the final payment, it's conditional on final payment. Does that help?
And then when you get your final payment retention, then you're going to do unconditional final. Say
Mhm.
you don't owe me anything else at that point. And that's when the financial part of the project can be start to close out.
Okay, so I think this one accidentally has a slide. So protection of work. What I really this is a clause I'm not really happy about. And essentially it's risk mitigation for the prime contractor and the owner. And it's pushing or putting the risk and liability of protection of a subcontractor's work back to you. And so the risk baton is passed to you. And so what they're saying is, I'm going to say an electrical contractor, you go in, you do your electrical work, and the protection of work is on you. But then the drywaller comes in, and I'm sorry for picking on a drywaller, comes in and makes a mistake. And if the protection of work clause is in there, saying you have to protect your work for the duration of the project, then you have to go in and fix it because you've agreed on this and you don't get extra cost for someone else's damages. So it's one of those things, and this is really important to negotiate on multi-year projects, that you should limit the protection of work to your scope for the duration that you were on the project. Robert.
No comment.
Okay, and then I'm going to go back to what Robert would have said if he'd said something and say, keep a daily journal of your work performed with document and date stamp pictures so that you can prove any damage that happened is not your fault. So make sure you are not responsible for somebody else's mistake. Next slide, please. Okay, this is a really big one that is often, there's two suggestions that I start with. The definition is of hold harmless is that you are indemnifying or compensating someone else and bringing them and making them whole. So hold harmless language is what it's called. This is oftentimes what you find in insurance. The thing is that you want to make sure you are not indemnifying beyond your scope. So if you have a limited scope, you should review and have your insurance agent to make sure you have enough insurance to protect yourself, review the indemnity language, and attempt to limit it to just your scope. This is a problem. For example, if you, and I'm going to exaggerate to make this example, if you are a plumber on the Millennium Tower that is leaning like the Tower of Pizza in San Francisco, and you signed an indemnity agreement that indemnified the architect and engineers, you are now on the hook for that leaning tower. I'm giving you the worst example so you remember it. So you want to limit whom you're indemnifying if possible. And so, Robert.
No, I will pass on this one.
There's a question, do we need to write a scope of work on detail in contract or detail in drawing is sufficient?
In terms of that, in terms of indemnification, Robert, I'm going to turn to you on that one because that's more, that wouldn't, that may or may not impact indemnification language.
It
Uh,
doesn't.
it doesn't. That has more to do with your expertise in your field. And that's expected of you. And so that would potentially be change order work, would how I would see it.
Right. Yeah, because you're the expert to provide a turnkey system or whatever it is at the end. So, like I said, it's on you.
But make sure you once again document it
Yeah.
and put in a change order for any extra work for drawings, submittals, and
Mhm.
so on and so forth.
Yeah.
But once again, read the indemnification language for whom you are identifying and have your insurance agent read it to make sure you have sufficient insurance to cover what you are indemnifying. Okay, next. Okay, so there are key takeaways to all of this. There is obviously more. Robert and I get kind of excited about this kind of topic. We could talk for hours, but so first off, just as a reminder, once you've signed the contract, previous negotiations are no longer valid. We want to make sure that everything you want to be in the contract is in the contract before you sign it. So what you're going to do is you're going to look at your contract for accuracy of things that you can control and you have submitted for control. That's including schedules, milestones, drawings, your estimate, your bid scope. Make sure that they're in there and in there accurately. You're going to also take a look, you're going to review certain sections to see if you can change them, as well as certain sections, and then see because of flow down provisions, see what impact there is and how that may change your contract. So, one of the things about this that's really important is once you start recognizing these terms, and I think Adobe Search is a great tool, they keep repeating. They're the one of the nice things about if you work, for example, the city of Los Angeles, they will have the same boilerplate language that will make your ability to understand the contract easier and more comfortable. But in terms of generalities from one contract to the next, they utilize the same language. And once you get used to it, it'll be easier. And then, as a reminder, you can negotiate where you can. It's people may say no, but negotiations are absolutely permissible. Um, and then, when in doubt, you know, um, get legal advice from counsel. We know that it's a cost benefit that you've got to look at in terms of how much it costs if you're first starting out. But that's one of the reasons why we bring these, so at least you're aware of the terms and you can take a look at them. Next slide, please.
One thing, I'm sorry.
No.
No, another takeaway for this is when you are reviewing this contract, when you're bidding the job, if you see a lot of red flags at the very beginning, be cautious if you want to proceed, because that's going to be telling you real quick, how this project is going to go because of a lot of red flags that you're seeing. Now, the other thing is, if you have too many red lines in your contract, the hiring agency might not want to work with you. So be strategic of what you want to negotiate in these contracts, because they see too much. You're like, hey, I don't want to work with these guys. So I just wanted to throw that in too.
No, it's absolutely correct.
Yeah.
Um, so, tips for contractor review. Understand the contract terms and the contract so that you're a better negotiator for yourself and that you can discuss it better with your strategic partners with whom you're working. If you can afford it, hire a lawyer to review your contracts. Understand boilerplate language. It does not switch. So Clark has the same contract. Hensel Phelps has the same, Skanska has the same contract. They use it again and again and again. Same with the city of LA. Same with the city of Houston. So when you are looking at the contract, use Adobe Acrobat to search for terms in there. So instead of having to read the whole thing, make sure that you go to, you can use the word reference or incorporate, or you can put in LDs or liquidated damages or warranty, all of those, so you can go directly to that section. So you know the problems that might be there, or you can look up the word indemnification, and so you can go to those sections. The last is we are starting a new era in terms of AI. And granted, just be aware that anything you put into AI, if it is not paid, is available as data for everyone to see potentially. But if you do have paid AI, we recommend that you put into AI your contract, and you can attach it, and the AI can give you a summary, and you can keep asking questions until you feel comfortable with it. And it can tell you the repercussions, and it does an okay job. It is not legal review. It is not the end all be all. And AI has a tendency to oftentimes to tell you what it thinks you want to hear. So just take it with as another tool that you can use. But these are some tips that you can contract review and utilize again and again to make sure you get a level of comfort with contracts. Next slide, please. Okay, so one of the things is with Meriwether and Williams, with the City of LA, LAWA, as well as Metro up in Northern California with the County of Alameda and the City and County of San Francisco. We provide assessments and targeted technical assistance to small and emerging contractors. With Robert, as you can tell, we have field support services that can help you and work with you on project management, construction management services for your contract. And then also we do a bonding support and funding support with working capital loans, project specific. And this also is one way to bridge that gap between, the 120-day payment cycle and progress payments that a lot of people are looking at. And it's just one tool that we just wanted you to be able to know and be aware of that we do through our contractor development and bonding assistance programs. And Connor can give you that information when you contact him, and he can put his email in there. Next slide, please. Okay, I know we've allowed for questions, but if everybody wants to unmute themselves and ask questions now, we'll be happy to hear them.
I have a quick question, sorry. Could you
Yeah,
hear me
sure.
this time?
Yes, we're excited.
Okay, I changed my to the phone and switched to the phone. Actually, my question is, do we need to write a scope of the work in the contract as well as detail and drawings? For example, to make sure that we are this contract is about this scope of the work, that we go through the estimating procedures or no, because most of the time I didn't see that the scope of the work was not mentioned. This is a specification, a general and general condition, and also a specific conditions actually. But do you think it's necessary, or is it better to write down the scope of the work in the contract, or just move forward to have that contract or sign that contract?
So Robert, I'm going to take a stab at it, and then you can. So usually what I see in terms of a scope of work is your project scope or your estimate is included and incorporated as exhibit A, B, C, or D into the contract. And so that you have already written your scope of work. One of the things is that's one of the things you need to look at for accuracy to make sure And if I think about it this way, I think yes is my answer because if you are defining your scope of work and your exclusions, that is going to protect you far better than if they hand you a scope of work and then you have to negotiate. If you've written the scope of work, you, through your expertise, have not forgotten anything and know what your exclusions are, as an example. Robert?
Right, and that comes down to scope gap too, because if you miss something, you're on the hook monetarily to cover that scope. Yeah, during the bidding phase, they might give you a scope sheet, and you just put in the quantities, but you still need to do your own scope. It's like, hey, by the way, I see this is missing, but on low bid, you're bidding exactly what's on the drawings, but you want to keep a running tab. It's like, hey, I noticed that you don't have this include because you need to make my system whole. So those are your adults that you can negotiate later as well, but you want to bid exactly what's on there onto the plans there. And yeah, they're going to write a scope in the contract, but it's not going to be very detailed. And that's where they're going to take, like Jen said, your scope of work and your pricing and attach it. They're not going to sign your contract. They're not going to accept your terms and conditions on your proposal because you're going to be working for them. So the more you have detailed as a sub to them, then they can work with you to make sure everything is covered for you, Amir.
Thank you.
Any other questions?
Yes, I do have a question. So would that apply to the indemnification languages? If you put your scope of work, then you wouldn't be on the line for the different things that they want you to do on the job?
So I'm sorry if I wasn't clear. When we're talking about indemnification language, it
Yes.
usually isn't just talking about your scope of work. What it does, it'll say something like, you will hold harmless the owner, the owner's representation, the architects, the engineers, and so on and so forth. And it doesn't mention scope of work, but you're holding harmless people that you shouldn't be holding harmless. Does that make sense how they make it a little convoluted?
Yeah. Okay. All right. Yes, it makes sense. Thank you.
You're welcome.
Hi. Question, a question regarding the scope of work. Usually when you bid on the job, you have your inclusions, exclusions. You're still bidding on what's on the bid list. However, you're qualifying things that what you will do and will not do. Now, in terms of making sure, let's say, for example, you're on a short list, they call you later, then at that point in time, you can negotiate with them to add on any exclusions or inclusions that you find necessary to move forward on the contract, on your specific contract, because you may have included them. However, if you get selected, if they're not on your contract, you have to make sure that
Yeah. Yes.
they're okay.
Yes. So essentially what usually happens is that you're selected. They send you over a contract filled out with certain things, what attachments, what the requirements are, and it oftentimes has all the forms, the conditional, unconditional, everything's attached to it. You're reviewing that, and at that point in time is when you're reading for that accuracy. Did the exclusions you included in your project scope letter, did that get included? Is it attached? Is the amount correct? And in that time, you can mark up and try to negotiate with them. You can obviously negotiate before the contract is generated, but this is the time where you're doing final negotiations from my perspective to work with them and make sure that everybody's on the same page. And as Robert said, it is a balance between too many negotiations and what's important to negotiate.
Yeah, yeah, the reason I ask it is sometimes if you start changing the terms, the bid terms, they may just throw away your bid. So,
Exactly.
so you want to make sure you include everything that they've asked for,
Hmm.
and then later, if you can then negotiate.
Yeah. Yeah.
Okay, okay. Thank you.
Absolutely.
Thank you.
Sure. Hmm.
Be careful on that because sometimes you want to win this job, you're going to lowball and say, I'm going to come back with change orders. Going back to that change order language, there might be a sentence in there that said no change orders allowed.
Hmm. Well,
So,
yeah, I'm just saying
yeah,
before the contract, but not for change orders.
but that's
Assuming,
part of it. It
yeah.
all
Oh,
rolls
okay.
into that too because
Hmm.
most people are like, hey, I'm just going to bid this. I'm not going to bid this. And also, if something is not on the drawings, don't include it because you want to bid apples to apples. But
Right.
keep that and say, hey, I noticed this is missing.
Hmm.
And they might accept that into your final contract. They can accept individual things later as you're negotiating
Right.
because that shows that you're showing best value on this because you really know what you're doing. Because even though public agency is low bid, it's rare that they say best value, but a prime is going to look at you and say, hey, what value can you bring to this team? So that's some of the negotiating that you want to do too, as well.
Ah, understood. Thanks.
You're
A quick
welcome.
question I have about on the conditional waivers. From general contractor point of view, do we need to take also from the supplier of a subcontractor unconditional waivers?
Yes.
And also how we can make sure that the subcontractor paid the laborers or another subcontractor that sometimes they use for their work.
So these are your subcontractors,
Correct.
laborers. So there's a couple ways to do it. Um, Essentially, it depends on how you've written your contract with them. And as part of the condition, you could ask for a subcontractor's bond for them to make sure that they're paying their subs, their laborers and their suppliers. You could also, you could put into your contract the same kind of conditional, unconditional waiver language to make sure that they're doing that as well. Because, it's true. You ultimately, as the prime, are responsible to make sure everybody gets paid on that project. Um,
Flow down language.
mhm.
Thank you, man.
Then you see the one in the chat? What recourse if agency refuses to adhere to prompt payment clause? Did that one get answered?
Robert, I'm gonna let you handle that one
Ooh,
because that one's hard.
read
That
the
one,
question again. I saw it earlier.
It says, what recourse if agency refuses to adhere to prompt payment clause?
What recourses?
Yeah, what recourse if agency refuses to adhere to prompt payment clause?
Oh, man,
so
go ahead. That's a
this is
legal thing.
yeah. So this is where I oftentimes this is where the stop notice is important
Hmm.
to make sure they're aware of it. This is where talking to the whatever contract compliance or compliance officers are on the project are there to help you mediate. And I'm assuming we're talking about a public agencies. Some of the issues that I have found is at certain federal levels, stop notices are not allowed. And so that one becomes very, very difficult in terms of the prompt payment. So like I said, couple recourse that you have is really the contract compliance officer stop notices if they aren't available, and then also essentially a letter writing campaign just to put some pressure to make sure that you get heard, with anybody at the public entity on the project. Robert, do you have any other resources? Because this one can be a hard one.
Like I said, it's just that stop notice. But most times, these agencies are going to adhere to it because where their funding is coming from for these jobs, they don't want to be non-compliant with the funding, because it's federal money, state, city, so they don't want to mess up either. So they're going to help you as much as possible. It's the key thing there. They're going to bend over backwards to help as much as possible, but you've got to let them know what's going on. As if you're a sub and you're not getting paid, you've got to let them know as well. Because like I said, the compliance, as you're doing certified payroll and all that, there's a lot of checks and balances that they have to do.
Any other questions?
There's
And-
one I just wanted to mention.
Okay, good.
Jen was talking about AI. There is a program called Document Crunch. It's an AI, it's a subscription you can pay for, but you can train Document Crunch to learn your business. You can then upload the specifications and it can find stuff, even your contracts. So, as we're shifting into AI, a lot of stuff. So look at what tools that are out there that you're comfortable with that can make your business a little more efficient and grow your business too. But that is one good one. It's called Document Crunch. I just wanted to throw that in there at the end. And then also with the finance that Jen spoke about, it's contract-based finance. So yeah, it's like seed money to get you started. But if you're interested, make sure you enroll into the program, and then you'll talk to your CDM to make sure that you have everything else so we can then start the process for pre-qualification. So if you're looking at bidding a job soon and you want to utilize this service, it takes about 30 days to get pre-qualified, but it's well worth it. So I just want to throw that out there as well.
Actually, I have quick questions. Robert talks about the CPM and if your scope of the work on the critical path or it is not. If you are in the critical path, your scope of the work, and the change orders take time and it has a time impact in your projects, do we need to actually inform that already the schedule going to delay because of your late process of change orders or late payment for the change orders? How we can handle that one, safely to move forward with the projects in addition to have more our change order.
Right. So if you're on a critical path and they're delaying change orders, that's what I was talking about, that time impact analysis. Like, hey, you know what? The end date is getting pushed out because of these change orders by the engineering design team. They're going to recognize that, but there could be times where we can't go past that end date. So you're probably going to, make sure you've got to, they say, crash the activity, get more resources on there to make sure that it doesn't really push out the end date. So you can say, hey, owner, yeah, I see there's this change order. I'm on the critical path, but this end date, is it firm or not? And if they say yes, it's like, okay, well, then you might have to have 2 shifts out there working and things like that. So that's understanding. If they say, hey, you guys still hit the end date, how are you going to do it? That's going to be extra money for you to still manage that. Time and material could be one way to push these change orders through with a not to exceed amount. Now, hopefully that answered your question there.
Right. Thank you.